Thank you, Madam Chair. Yes, much better. I'm joined by my colleague Bob Goodlatte from Virginia. We'll be joined during the trial by our colleagues Hank Johnson, Jim Sensenbrenner, and Zoe Lofgren. We were also assisted by some very able counsel, Alan Barron, Mark Dubester, Harry Damelin, and Kirsten Konar. At the outset, the House recognizes what an extraordinary proceeding this is and how seldom an impeachment is undertaken. I think this is a reflection of several things, not the least of which the caliber of the men and women who are nominated for the federal bench, the vast majority of which who have acquitted themselves with great distinction and not given cause for their removal from office. I think it's also a tribute to the confirmation process that does a good job in vetting out those who are not suitable for the bench. And I also think it's a reflection of how infrequently the House believes that this extraordinary remedy is required. I won't spend much time this morning in discussing the standard for impeachment, the content of high crimes and misdemeanors. There will be time for that later. More than that, I think the members of this committee understand that standard probably better than I or anyone else could articulate. But I will share, at least in my view, one of the formulations I think House and Senate have arrived on in considering judicial impeachments. And that is that a judge has committed a serious violation of the public trust. That in the phraseology of Governor Morris, one of the framers, that the judge has so misdemeaned himself by violating the public trust that it necessitates his removal from the bench. And I also say that in the unanimous view of the House of Representatives, the conduct of Judge Porteous was so unethical, so deplorable and inimical to the public trust that he cannot be allowed to remain on the bench. Now, what was that conduct? I'd like to give you a brief overview of the facts of the case before I turn over to my colleague, Mr. Goodlatte, to go through the evidence in more detail. But before I do, it's worth pointing out that the vast majority of the facts, the underlying conduct in this case is not disputed. The central conduct in this case is simply not contested. And that conduct involves four areas. It involves the judge's relationship with two attorneys, Jake Amato and Bob Creeley. It involves his corrupt relationship with a bail bonds company run by Louis Marcotte. It involves the concealment of the corrupt nature of his relationship with these attorneys, with this bail bonds company during his Senate confirmation. And it involves his numerous false statements and representations and violations of the bankruptcy court order during his bankruptcy case. Let me start first with the lawyers Amato and Creeley. The evidence will show that he had known these lawyers for a long time, that he had in fact been a partner of theirs in their law practice before he was appointed to the state bench. That at some point while he was on the state bench, whether because of his expenses in the course of his family occasions, weddings or whatnot, whether it was because of his gambling or his drinking or his taste for expensive lunches, he started asking for cash from one of the attorneys, Creeley. In the beginning, it was small amounts, $50, $100, whatever Bob Creeley had on him. But over time, he became to ask for more cash, $500, $1,000. And at some point, Bob Creeley got tired of being hit on by the judge for cash. And he told the judge it had to stop. The judge had to change his lifestyle or do whatever's necessary, but the cash had to stop. And after they had this conversation, the judge started sending curatorships to the law firm of Creeley and Amato. Curatorships are essentially small administrative cases, often when there's an absent party and it's necessary for someone to take an ad out in the paper or do other administrative tasks for the court. These cases weren't worth very much, $175 or $200. Amato and Creeley will testify they didn't even want these cases. They didn't ask for them, they didn't want them. But once the judge started sending these curators to the firm of Amato and Creeley, he started again to hit them up for cash. He would call and he would want some of the curator money. And the evidence will show that they started to give him basically 50% of the curator money. The evidence will also show that they continued to give him curator money, and they would both take a draw from the firm. They would each basically get $1,000 as a draw from the firm. They would then turn that into cash and give the cash to Judge Porteous. This went on for a period of time until Judge Porteous was nominated for the federal bench. Once he was appointed to the federal bench, he was no longer in a position to send curators to the firm of Amato and Creeley. When the curatorship stopped, the cash also stopped. Now that cash stopped, and the request for cash stopped with the end of the curators. When he was appointed to the federal bench, the request for cash stopped until a certain point. And that point came when Judge Porteous was assigned a multi-million-dollar piece of litigation called Liljeburg versus Lifemark, involving a fight over a hospital contract and a pharmacy within a hospital, a very complex case that it's not necessary to go into great detail about. But this case had been going on for years. 6 weeks before the trial, Liljeburg brings in, among others, 2 new lawyers, and one of them is Jake Amato. The other is a lawyer named Levinson. Opposing counsel, a gentleman named Joe Mole, became concerned with the late addition 6 weeks before trial in this multi-year, very complex, multi-million-dollar, perhaps as much, the evidence will show, as worth $200 million. Very concerned with the late addition of these lawyers, so he did some due diligence, contacted people that he knew that understood the bar in New Orleans. And what he was told really alarmed him, that basically the thing that these 2 attorneys had in common, Amato and Levinson, was they were close friends, basically cronies of the judge. And they were told in no uncertain terms, Mr. Mole was told, not by people who wanted to identify themselves, not by people who would speak publicly, but the fix was in, that they better make a good record for themselves on appeal because they were going to lose the case. Now this put Mr. Mole in a very difficult position because the case was a bench trial. There was going to be no jury. Judge Porteous was going to decide the facts. He was going to decide the law. He was going to write the order. And Mr. Mole didn't have hard evidence that he could cite to. Most of what he was told, basically was told in a way that he could not use in court. But he did know that they had lunch together, although he did not know how frequently. And he was able to find through court records that he believed that Mr. Amato or Mr. Levinson had given a contribution to Judge Porteous's campaign. And these were the only facts he really could cite to: their friendship, this campaign contribution, having lunch together, in his motion to recuse. But he felt he had no choice. He had to try to ask the judge to remove himself from the case. So he files the motion. The judge makes it quite clear during the recusal hearing, and we will share with you the transcript of that recusal hearing because it's one of the most illuminating pieces of evidence in the case. The judge makes it clear he understands the ethical standards. He understands when he has to take himself off a case. He goes through that with counsel. And then he chides Mr. Mole for suggesting that he'd gotten a campaign contribution from Mr. Amato, Mr. Levinson. He says, I never had a campaign. The contribution you're talking about was a contribution to all the judges for all their campaigns, a program that was called Justice for All, contributed to all the judges' reelection. That was the only money he got from these lawyers. Now this, of course, we know was a quite deliberate conceit and misrepresentation because, in fact, he'd gotten thousands and thousands of dollars for these curatorships from Mr. Amato and Mr. Creeley, none of which all he does is chide the attorney for not doing his homework. Of course, if Mr. Mole had really done his homework, if he'd been able to do the homework he needed and found out about all this cash the judge had received, the recusal motion on appeal, because he later appeals, and the Court of Appeals, of course, doesn't know the information and denies it, the appeal would have been successful. The judge would have been forced to recuse himself. But the judge doesn't. He rules against the motion. The appeal is denied. The case goes to trial. After the case goes to trial, Judge Porteous takes the case under submission. This is worth an enormous amount to the law firm of Amato and Creeley. They have a commission arrangement. It's a contingency case. They don't make a penny unless they win this case. And if they do win, Mr. Amato will testify they stand to earn somewhere between $500,000 to $1 million. He's taken no other case in 2 years as Mr. Amato's worked on this case. It's worth an awful lot to his firm. Case is under submission for 3 years. While it's under submission, they continue having their lunches together. The evidence will show that Creeley or Amato had, Levinson had lunch